Hi everyone. I wanted to create this video about testifying during TPRs because I know a lot of you have a lot of anxiety and stress once a TPR hearing is coming up, and you're a little confused as to what attorneys might ask or what might happen during the hearing. And I want you guys to have as much information as possible when you walk into that courtroom so that you can be a little bit more comfortable and understand the process a little better. So in order to understand the process, I thought maybe if I discussed how the TPR process actually starts, and that's beginning with the petition. So DCS can file a petition to terminate parental rights on cases where the child's been in the system for the past 15 months out of the past 22. So if your case has been open for 22 months and they've been in placement for 15 of those months and out of the home, then DCS can legally file a petition to terminate parental rights. They can also file a petition to terminate parental rights if the child has been out of the home for 6 months past the dispositional hearing. So I put some notes up here on the board that I want to go over with you on that. And DCS, once they decide to file for terminate your CHIN's case, they will file a separate cause number. That's another thing I want to talk about, a separate cause number. You guys have a case that looks like the CHIN's case up here, and you have this JC number. But in a termination case, you are going to have this JT number. Now, when DCS files to terminate, it's a totally different cause number. You're not on that cause number yet. So what I will do, I will attend that initial hearing. The judge will say, hey, I'm going to appoint CASA, and then I will file to appoint our program, and then I file to appoint you to that case. And typically, DCS termination hearings on terminating parental rights is usually just 3 hearings. So that would be the initial case, the initial hearing, and you're not there. The pretrial, which you don't have to be at the pretrial, and then the actual fact finding. So typically it's 3 hearings, and you don't do any reports, but you do need to testify. That your testimony in that hearing is the most important testimony you're going to do for the life of this case. So you need to remember that. And once they have those 3 hearings and our judge makes his decision, then this cause number is ended. It's decided. So it's done. And that's just kind of hard for some people to wrap their brains around. But DCS decides to file for termination. They will file a separate cause number. There will be an initial hearing. Parents will be advised of their rights. Parents will be appointed counsel. The judge will set a pretrial and fact-finding date. CASA will be appointed. After the initial hearing, I will assign you to the TPR just as I did your CHIN's case. After the termination fact-finding hearing, the judge will make a ruling to terminate parental rights, or you could find that DCS didn't even prove their case and not terminate their rights. After our local judge makes his decision, the TPR case is closed for us in this county. Parents' attorneys can appeal the judge's decision to the state level, but we're not involved with that process once it goes there. Appeals courts always look for CASA testimony from the fact-finding transcript before filing their final opinion. So what that means is, if there was a CASA testifying at a TPR hearing, when it gets to the state's level where the appeals Supreme Court looks at this and tries to base their opinion on this transcript and the facts and all the filings, they're going to look in that transcript and say, hey, was there a CASA pointed to this, and how did the CASA feel about this? And they always quote the CASA in their final opinion as to whether or not they uphold the judge's ruling or not. So I've had a lot of CASAs that have gone to fact-finding hearings, and they have said, hey, I don't think I got my point across. I don't think I had a good testimony. I felt like the attorneys were really rough with me. I feel like that I did not testify in the best interest of the child. I felt like I didn't get that point across, but you do, because they look at it and they quote it in their final opinion. So it does make a difference. And this testimony that you have during a fact-finding hearing is probably the most crucial testimony you will give throughout the life of your child's case. So that's something really important to keep in mind. I also have a handout that you guys are going to be coming in the office and picking up so that you can have and be able to look at it and refer to it whenever you want. But when you come in here, I'm going to make sure that you sign something saying that you got it. But we're going to go over this as well today because I want to make sure that you guys understand all of this. So one of the first things that I highlight here is always refer to the judge as your honor or judge. Always be respectful to the judge. Even if you feel like the attorneys are being brash with you or harsh with you or negative, Always be polite to them. Always be polite to the judge. Always, always refer to the judge as judge or your honor. Understanding the testifying process. You will be called to the stand, sworn in, and asked to take a seat and get comfortable and speak up. Speak up. They will also generally, do the whole thing where they say, "What is your name?" and spell your last name. So remember, don't stumble around on that. Know how to spell your last name. There's the direct examination which would basically be by DCS because they're normally the ones that call you to the stand. That's telling a story, who, what, when, where, how. And a lot of times they will ask you questions, how long have you been at CASA? What is your training process looking like? I also have paperwork on that with some examples on the type of testimony that you could give with that. And then I will include that with this when you come into the office to pick this up. So you will have all of that to read over. And you can refresh yourself whenever you have a TPR hearing coming up or you feel like you're going to testify and you need to refresh. Then there's a cross-examination. That will typically be DCS because normally, that will typically be the parents' attorneys because normally DCS is the one that calls you first. So they'll be trying to pick apart the story, and they'll try to use leading questions, but these are typically yes or no questions. So if you can answer something with a yes or no, do that. And then you don't need to take it personal. Whatever they're doing, do not take it personal. Then DCS has a chance to redirect. So if there's anything that they have a concern about during your testimony with the parents' attorneys, they can raise that on their cross-examination. Also remember that at any time during your testimony, the judge can ask you questions. So always remember that that is something that can happen. And always remember to look directly at the judge and answer him as honestly and truthfully as you can. Also, your appearance, we talk about that all the time. Because the CASA program, we want the utmost respect in the courtroom. We always want to appear professional. We don't want any food or drink. We don't want any gum. We don't want cell phones in there. But just remember that this day is probably one of the most important hearings that you're going to attend on your case. So you need to dress appropriately. This is a day where it's going to be very important, emotional, and life-changing day for a lot of people. So you need to communicate that in your dress. It's important to come across to all parties and the judge that you show respect for the court and that you're taking this very seriously and that you want to put your best foot forward while you're practicing for the best interest of these kids. So it's important to also note that while we want you to dress appropriately, this isn't a fashion show. So try to remember that and not to be too flashy. Don't be extreme. Don't overdo it. It's best to dress in a manner that you want to be taken seriously, but that you also want everyone in that courtroom to remember your testimony, not your outfit. Okay? So if you keep that in mind, I think that'll be very helpful and for you to help you pick out something to wear appropriate for court. And typically you guys do a great job with that, so I don't think there's any worries with that. Review your logs, records, case files, notes. Make notes of specific dates. It's okay to create a timeline and important events. And you can have those notes with you, but you'll have to ask the judge to take them up in the stand, or you'll have to ask the judge to refer to them if you want to look at them about a date or something. Be sure to always ask to refer to your notes. So you'd want to say, Your Honor, I need to refresh my memory. May I look at my notes? Make sure they're legible and make sure that you only have factual information in there, no personal feelings, no nasty comments, because the judge or attorneys could look at these notes and you don't want to appear tarnished or biased. So make sure that you don't have any of that in your notes. They're just factual, documented notes. Be prepared, not scared. Okay, so always keep in mind this is not about you. It's about that child. Sometimes lawyers cross as just a bunch of nonsense and attempts to confuse you or mess with your head. So you just really need to stay calm. Sometimes they're not going anywhere with that. They just want to knock you off your game. This is one that I really promote all the time. I want you guys to speak loud. I want you to open your mouths. I want you to speak slowly and clearly. So remember that, because everything will be taken down by a court reporter, and it's entered into an official transcript, like we said before, and then the appeals court can see that, and they read that, and they try to gather information from that. So be sure to respond yes or no, rather than shaking your head or nodding. Uhs or nods, those don't go over well. If your statement's not clear, it will be entered in the transcript as inaudible. And I have read transcripts where there's word, inaudible. Word, inaudible. That's very hard to read and it's hard to understand, and I don't know what point you were trying to get across. Also, try not to talk at the same time as everyone else, including the prosecutor, defense attorney, or judge. Wait for the question to be asked. Listen carefully and then begin your answer. Make sure you speak loud enough for everyone to hear. So just try to remember that you don't have to jump in there as soon as they ask that question and answer it. Take a beat, think about it. And if you have to, ask them to rephrase it. It's not a game show. You're not going to win a prize for jumping in there and just saying whatever really quickly. So just take your time, take a beat. Try to make complete sentences without a lot of ums, and try to avoid saying I assume or I guess. Don't say honestly or truthfully. Like, truthfully, I want to tell you that because you were already sworn in, so you swore that you would be truthful. So to say it now, later in your testimony, appears that maybe you weren't being honest up until then. So I'm sure you're not trying to say that, but it appears that way to people that are listening. Watch your body language. No slouching, no leaning, no eye rolling. So, we could all take personal note of that. I know I surely can. General testimony. Relax, breathe, listen closely and actively, take your time, answer only what is asked, be concise and precise, tell the whole truth, stop talking when an objection is made, facts and details are better than conclusions, ask for clarification or rephrasing if you do not understand. If you do not know the answer, say you do not know the answer. Be courteous, talk loudly, give audible answer, don't shake your head. Look at people when you're testifying. So whoever you're talking to, look at them. Don't look down. Don't look around. And I know I said don't say Don't guess. Don't give personal opinions. Don't use DCS jargon or acronyms. Don't try to understand where the questioning is going. Don't make assumptions. Don't be afraid to give credit where credit is due. Don't take it personally. Don't worry about how your answers appear. Don't stress out about cross-examination too much. Don't lose your temper. Don't argue with the lawyer. Don't look to the lawyer for help. So I know that's a lot to take in, and I know you're probably still nervous. I'm going to go over a couple of other things that I had down here. I know I had something about testimony, about objections. So we're going to go over that. What do I do when an attorney makes an objection? When there is an objection, stop talking. When an attorney makes an objection, the judge will either sustain, which means no, you may not answer, or he'll overrule it and you may answer. If you forgot the question, just ask for it to be repeated. Don't interrupt when being questioned. Don't respond to silence. Wait for a question. Attorneys know that silence makes a lot of people nervous, so sometimes that's just one of their tactics. They have a lot of tactics, so it's good to be aware of them. And that's why I always say take a breath, take a beat, because they're just trying to get you off your game. If an attorney says something that is not a question, wait for the question. If you were asked about a specific document, then ask to review or read it to refresh your memory. Okay, so for instance, if DCS says, did you sign a case plan that said this, this, and this on such and such date? Say I need to see the document to refresh my memory. Could I please read the document? And read it when they give it to you. And that's the other thing. It says if you're asked to read a document, read it. So if they give you something and they say, are you familiar with this document? Do you know this document? Do you remember when this document was signed? Or do you remember reading this? Then actually read it and read through it and see what it says. And also don't assume that the attorney's account of a document is accurate. That's why I said if they mention a document, ask to read it, because just because they're telling you something is specifically in that document doesn't mean that it is, and they may be taking it out of context. So you make sure that you read it and you know what they're talking about before you say anything. If you remember that something you said was not accurate, then correct it. Listen to the complete question. It's okay to say, I don't know. Always, always be honest, even if you think it hurts the case. And then we already talked about appearance. There was a couple of other things that I wanted to address about testimony. Also, this is the questions attorneys may ask. I will also put that with this. There will be a lot of reading, but it's a lot of information for you to have at your fingertips. If there's anything that comes across that you may wonder about, or it's just good for you to read before you do a testimony. I wouldn't say the night before a hearing be up cramming. I don't think that's a good idea. But about a week or so before your hearing, refresh yourself on some of these, refresh yourself on, and make a list of your notes. I think that would be very helpful. When I was talking about some of the questions they would ask you, a lot of times they're going to ask you how long you've been a CASA and what is your role as a CASA. So just so you don't stumble over that, try to already have that thought out in your head. If you want to practice at home in the mirror, that's really helpful, or have someone that you can practice in front of, not using confidential information or anything, but I think that could be really helpful. It could also be helpful with learning how to project your voice and how to speak loudly and clearly in court. They'll talk about your involvement with the children. They'll talk about, how much time you spent with the children. Please don't get up on that stand. You have to be honest. So be honest with me prior to a fact finding. If you've not been seeing your kids or you haven't had regular visit with your kids, please don't get up on that stand. And I don't want anybody to ever get up there and say, I don't know, I haven't seen him in 6 months. So just remember that too. Let's see. The cross-examination by the parents' attorneys, sometimes they're going to ask you questions about, I know they did in Angela's case one time. It seemed like they were trying to convey that she just does whatever DCS wants. Like, are you always on board with DCS? Do you ever think parents should be back with their kids? Things like that. So don't let that mess you up either. And if you've only ever had one case, you can say, I only have ever had this case and I'm on board with termination on this case. So just say that. Know your record, organize it, prepare it, speak loud, speak clear. I cannot get that across enough. Your notes are your friend. And tell the truth, and I can't say that enough either. Normally, answers are just yes or no answers. It's not, you just need to make sure, because sometimes if you ramble on and on, then they'll pick up on something you said, and then they'll have more questions based on that. So try to keep your answers at yes or no. They have lots of different tactics they use. We went over several of those while I was going over the documents that I prepared for you. Another one that I wanted to talk about real quick was, why does this child need permanency? So while you're up there on the stand, and you get hit with that question, even though you know why you've been doing this and you know why permanency is important, sometimes you're drawing a blank. So if you have to, take a moment and then just take a breath, or you could even ask them to repeat it. And then you could just let them know that this child needs permanency so that they can feel safe, secure, loved in a home where they know they will be forever. That's why permanency is important to these kids, because then they know that they're in a forever home. If we're just out there in the system, that's not permanency. So just get that point across. And during your testimony, you need to always be conveying that you are there for the best interest of the child. You're not there because you feel like this is a good decision for DCS or a good decision for parents. It's what you think is in the best interest of the child, and you need to say that. And then it says, sometimes they'll question how many visits you had, even if it was an appropriate amount of visits. If it was 12 visits for the year, then it was 12 visits for the year. But if the attorneys say something like, was having 12 visits to the foster home sufficient for you to support your recommendation? Yes. So you don't need to ramble on and on. You can just say yes. Like I said, most questions are yes or no answers. And then they can elaborate if they want. That's on them. And you say yes, and they said, why do you believe this was sufficient? Now you can elaborate. So I maintain constant conversation with the foster home, because a lot of us are in constant communication with the foster home, placement, providers, so that you can say that, that was not your only means of advocacy for this child. I was in constant contact with foster home, constant contact with the FCM. I attended all court hearings. I attended all CFTMs. I had phone calls with the children. We had FaceTiming, and I have absolutely no concerns about this child in this foster home or this placement. I think their needs were met there. Those are the kinds of things that you can say if they ask you why you believe whatever amount of visits you had was sufficient. Because, hey, I did all these other things on top of that. And I also feel like there are no safety concerns. All their needs are being met. So I just want to make sure that I got that across, because those are sometimes, even though we know the answer, it kind of hits us really fast, and then we're just sitting there like, what did I just say? And then you come up empty. So like I said, refreshing yourself with your notes, practicing in the mirror, practicing with somebody else, but with no confidential information, of course. You can use little Tommy or whatever you want to do, but just practicing it can help you through that process as well. If you would like to come in here and have me practice that with you, that would be fine too, as long as I'm open and available. Just give me enough notice to do that. I have no problem helping you guys out whatsoever. I think most of you do know that. There were a few other issues that I wanted to go over really quickly with you guys, and that was just a few policy issues. And a couple of those were, one of them was, from now on, I would prefer, because we've had a few issues come up, and like I said, everything you do reflects on the program. So we always want to appear unbiased. We always want to appear ethical, and we always want to appear professional, and we always want to appear that we have the best interests of the children in mind, so that nobody asks any questions, and their, placement doesn't have concerns, and DCS isn't asking questions. Just make sure, even though you're allowed to give a child a gift card, that you ask me first and talk to me about it, and just don't tell me afterwards. I need to be notified whenever you're giving a child a gift card, where that gift card is to, and the amount. And that's the only thing. Those are just the three things that you have to do with that. Just let me know. Let me know where you plan on getting it, and let me know the amount, so that there are no issues in the future. And I said, don't say Know when your hearings are, and have your reports in a week prior to the hearing, including a picture. The judge really enjoys seeing the pictures. I enjoy seeing the pictures. It brings that personal connection from the judge to the case that nobody else is bringing to the table but you. So it's really important that we do that. And I want to make sure that when you turn your reports in, you're sending me a recent updated picture, and I really, really appreciate it, and I know the judge does too. So that's something that I want to make sure that we continue to do. Another thing that I want to talk about is get those logs in. Don't wait 3 months to get your logs in. It's a lot easier, let me tell you, because I've had the same issues. It's a lot easier to do it when it happens, or do it that week. Do it as quickly as possible, but just get it done. I've got state sending me emails, oh, there's been no action on this case, and I know very well that there is, but I'm just hearing that there isn't. So I just want to make sure you get those in, and we're at the end of the year here, and we're getting ready to do our quarterlies, and we've got a lot of reports to run and things, so I really, really need those logs in when I ask for them. And finally, I just wanted to pat everybody on the back, because this has been the craziest year ever, and I think you all know what I'm talking about. So you guys have done such a great job. You've gone above and beyond, trying to find different ways to visit with your kids, different ways to communicate with the team. And at one point, where we're having weekly family team meetings, which was just crazy, and you guys were doing those. You guys were giving me plenty of feedback. You guys were getting to court, making sure your reports got to court. And I mean, it's been a crazy year. A lot of people have had to do a lot of different things. You guys have had to think outside the box. You have been staying on top of your cases, and I just really, really want to applaud you guys. I appreciate it so much. Like I said, everything you do reflects on the program, and you guys have just been really, super troopers during all of this, and I appreciate it so much, because I know it's been a crazy year. And not just from your cases, but on a personal side too, because some of this COVID and the pandemic and the issues have really affected you guys on a personal level and in your homes, and you guys have done your very, very best to do your best on your cases. And I want you to know how appreciated you are, and how much I appreciate all of it. And not just, because of the COVID issues or everything, but every day I appreciate you guys. And I know I don't always do a good job letting you know, but I want to let you know. I really, really appreciate you guys. So thank you for all that you do. You guys are the best. And we may be small, but we are mighty together. Thank you so much. And like I said, if you have any questions about this video, let me know. But I do want everyone to start getting with me about coming in and picking up this paperwork and signing that you've got it, so I know everybody has as much information as they can about testifying at TPRs. And I hope it was helpful, and I hope you have a good evening. Bye, guys.